the book left on them. Just bear with me. She is assisting me with something. Thank you.
You may proceed.
May it please the court. Mr. Hatuikulipi, if we may just move ahead. We're on document 51. See, there's an email from Egil Anderson to you, and there's two attachments: letter to the Minister of Fisheries, Highness Investment Final. And there's a letter attached. The subject is investment in the fishing vessel Heinaste. The letter is addressed to the Minister of Fisheries, then Honorable B. Isau. Now, instead of course, it's quite a lengthy letter, but if you can just inform the court, what do you make of this letter to the minister, but which was this email from Egil Anderson, which was addressed to you with this letter?
My lord, this email is for Egil. Egil is the guy that took over from Johannes after he resigned from Semeji, or after he was fired, my lord. So this is a letter that is sent to me, that they've sent to the Minister of Fisheries, Mr. Bernard Esau, for investment in the fishing vessel Heinaste. So this letter is from JV5 Epango, represented by TB Kandanga, Ale Arneson, SCF Investment, Semeji, Virgilio de Souza, 5 JV2, and Henok Atanga, Yuko JV7. So basically, they are just briefing the minister about their investment in the fishing vessel and explaining why was the flagging of the vessel delayed. So they were updating the minister that they found a solution and they are working on it by flagging the vessel. And these are the JVs, my lord, that we have convinced to sign long-term catching agreement with Semeji, my lord.
Is it the same JVs 2, 5, and 7 that you mentioned before?
That's correct.
Your Lordship, if this email together with the attached letter may be marked as Annex B54.
Yes, it's marked Exhibit B54.
May it please the court. Now moving on. See, there's an email from Ingolfur Peterson addressed to you. Johannes Stephenson has been CC'd, and the subject is agreement. It says the attachments consulting agreement, Erongo.
Oh, JTH.
Yes. Okay, I'll just read. It's a very short thing. Email says, "Hi, TAMSON, as discussed, we will need agreement for the attached invoice. Prefer before audit starts after 4 weeks. Can be similar to contract we did with EC and F. Regards, Ingo." Now, first of all, who is Ingo Peterson?
Lord, Ingo Peterson is was the financial manager of Semeji in Namibia at the time.
Okay, now there's this email he wrote to you, and it talks about an attached invoice. If we look at the subsequent page, there's JTH Trading CC.
That's correct.
Invoice to Memaria Seafood Namibia. It's an invoice of 1 million Namibian dollars, and it's indicated consultancy. If you can just explain to the court what you make of this, the email from Ingo and the attached invoice.
My Lord, there is an email from the financial manager of Semeji at the time, Ingo Peterson, sent to me with Joanna Stephenson copied into. So this email indicates how Semeji needed me to conclude the consultancy agreement between JTH Trading and Mer Maria for me not to delay their obligation under the law, including audit, my Lord. So, my Lord, as we know that an audit of a business are backward looking and the correctness of business activity. This being the case, my Lord, a dummy agreement cannot be part of an official audit, my Lord. So here is indicating that there is an attached invoice of 1 million. So there was a verbal agreement before the agreement was signed, my Lord. As I have testified that Cutler Seafood was sold to a Russian company, and this necessitated the new consultancy agreement, my Lord, between JTH and Mer Maria. JTH is my entity that I elected to enter into the new consultancy agreement. So we all perform our duties. I continue to do my work. So they paid me for my invoice before we have signed the actual agreement. First we were in a verbal agreement, my Lord. So they are now indicating I must conclude the agreement as soon as possible before the audit starts, my Lord. And this is from the additional disclosure, my Lord, provided to me on the 1st of June, 2023.
Yes.
May it please the court. Now, just for completeness sake, just want to look at the last page after the invoice itself, where it says the heading is agreement, again from Ingofu Peterson to Joanna Stephenson. You have been copied there. It's very short, so I'll again just read that part. It says, "Hi, this agreement needs to be signed. It's copy and paste from EC and F agreement last year. Check registration number for GTH and address and dates if you want to amend them. Since first invoice in 2016, I assume agreement is starting 1st of January 2016. Regards, Ingo Peterson."
My Lord, this is again an email from Ingo Peterson, the financial manager of Semeji, sent to Johannes and myself. So the agreement was ready to be signed, my Lord. So he's informing me that it's the same agreement as Erongo. ECF stands for Erongo Clearing and Forwarding Agreement, my Lord.
Your Lordship, may this email and the attachment be marked as Exhibit B55.
So you are saying that this
agreement was preceded by a verbal agreement.
Yeah, before it was signed.
Yes.
Remember, I testified that Cutlass Seafood was sold to a Russian company. Cutlass Seafood had an agreement with Erongo Clearing and Forwarding. So when Cutlass was sold, we entered into a new agreement. After it was sold, it was necessitated for us to enter into a new agreement. So I elected my company as JTH that need to go into the new agreement. So we first went into a verbal agreement and informed them that I will use my company while they are preparing everything.
Yes.
So I continue to perform my duties. So they pay me for my work.
Verbal agreement.
On the verbal agreement. Okay. So they chose. So they were informing that we need to conclude the agreement now.
This will be exhibit
B55, Your Lordship.
B55. May I proceed?
May I please the court. Now moving on to 53. The heading is JTH trading invoice not valid. It's an email from Egil Anderson, dated Friday, November 17, 2017, addressed to you. It's a very short email, and I'll read it out. It says, "Good morning, sir. The attached invoice from JTH Trading is not valid for VAT purposes. It was selected by the Ministry of Finance for VAT audit purposes. The invoice states invoice at top. It should read tax invoice or alternatively VAT invoice. Best regards." And there's an attachment. So if we look at the next page, is the invoice.
Oh, you said, can you have this fixed?
Can you have this fixed and send it back? Yes. Best regards, Egil. Yeah. So then the next document is the invoice itself from JTH Trading CC, dated 24 August 2017. Now, if you can just explain what you make of this, the email you got and the attached invoice.
So, my lord, the email was submitted to Mary Maria Seafood, and Mr. Ale sent it back to me. He told me that when they were submitting it for VAT purposes, the officials from the Ministry of Finance detected that the invoice only indicate invoice. So, my lord, that was just an administration error. It was corrected, and it was sent back to them, my lord. This clearly shows, my lord, that invoices submitted to Semeji that were provided for consultancy services were in fact submitted for VAT purposes. Because much has been said that invoices that are submitted were dummy invoices, my lord.
Yes.
May it please the court. Your Lordship, may this email and the attached invoice be marked as Exhibit B56.
Exhibit B56.
May it please the court. If we look at the next document, 54, it's an email from Sharon Neombo, sent on January 23, 2012, to Johannes Stephenson, and subject is invoice. Attachments, SJA invoice, 23 January 2012. It's very short, so I'll read it out. Dear Johannes, as discussed, kindly find the invoice together with our banking details attached. Please let me know if you need anything further. Regards, Sharon. And if we look at the next page, there is an invoice to SJA Marine Fishing Pty Limited. And the description is consultancy fee. The amount is 1.5 million. What do you make of this?
My lord, my previous bail application, Mr. Kanyangela testified that invoices that I've submitted are dummy invoices because the description only shows consultancy fees. So the additional disclosure that was provided to me on the 1st of June 2023, this invoice was disclosed, my lord. of party of a person of interest, Sharon Neumbo, as we know that she is witness number 152 in the witness list for Namgoma. So this invoice dated on the 18th of January 2012, description shows consultancy fees, amount 1.5 million, my lord. So much has been said about my invoices that only indicates consultancy fees, but same invoice, my lord, it shows consultancy fees, and nothing is being said about it, my lord.
So if I get you correctly, you are saying this is an invoice of a state witness,
Correct.
which you derived from the additional disclosure,
Correct.
which she invoiced to Estia Marine Fishing,
Correct.
and it contains, the description is the same as your invoices, consultancy fees.
Correct.
Yes.
And SCMR Fishing is a major subsidiary, my lord.
Okay.
Yes.
May it please the court, your lordship, if this may be marked as exhibit B57, the
So-
email as together with the attached invoice.
Yes, it's so marked.
May it please the court. Now if we move on to 55, talks of invoice to be amended. It's from Irene Rodriguez Pasco to you for on 30th of July 2018. It's very short, also, so I'll read it out. It says, Dear Tamson, please note that the company Kari changed its name into Saga Seafood Pty Limited and also its physical address. Can you please amend the attached invoice and send it again with correct name? Updated company details are as follows. Saga Seafood Pty Limited, Martima Building, corner of 9th Road and Theo Ben-Gurion Street, ground floor of 1004 Wovish Bay, Namibia.
So, my lord, this is an email from Irene informing me that Kari Investment, the name has changed to Saga. Kari is a company that is having an agreement with JTH Trading, my lord. So I submitted an invoice, and she informed me only after the invoice was sent that the name has changed. I must change the details. I must change it to Saga Seafood, my lord.
Yes.
May it please the court, your lordship, may this email be marked as exhibit B58.
Yes, it's marked
May it please the court.
B58.
Now, if we move on, 56 is quota fees and levies comparison. It's an email from Egil Anderson, dated 23 March 2018, to you, and it's also equally very short, so I'll read it out. It's, Dear Tamson, I have put all details of the increases in levies, etc., in this sheet attached. Here you can see the total increase between years. Just for your information, then Arctic Nam lost 15 million Namibian dollars in 2017 due to low fish prices, etc. We have no chance in 2018 if this is going to be the case, and the authorities do not change this. I've also sent this email to JVs so they realize what is going on. The example attached is based on one vessel operation with 30,000 ton quota. Attached is quota fees and levies comparison. And there is an attached document. There are quota fees and levies flagged, quota fees Namibian based, quota fees Namibian flagged vessels. What do you make of this email and the attachment?
My lord, AIL is updating me, or is letting me know that the increases in levies for the quota fees, export levies, observer levies, and research levies. When the prices were, when the levies were increased, Arctic Nam lost 15 million in 2017. Actignam is a joint venture company for the 3 joint venture with Semeji. So he's informing me that if this continues like this in 2018, things are going to be tough. And he's informing me that he sent the same to the JVs. And after that, he sent me the diagram that shows now 2017 and 2018, 30,000 metric tons. In 2017, research levy was 750,000. In 2018, it went up to 5.7 million. Observer levies, horse mackerel, in 2017, it was 2.5 million, 65,000. 2018, it was the same, did not change. Export levy, it went up. It was 3.8 million, 81,250. In 2017, it did not exist. Quota fees in 2017 was 5.4 million. In 2018, it will be 42,750,000. So it's just, or do I need to? It's not needed. No. Yeah.
So why was Egil Anderson sharing this information with him?
A lot. As I have testified, we are the one that convinced these JVs, and I have agreement is in place, and this is also part of the 2 pillars, my lord, because it's dealing with the JVs, and this shows the legitimacy of the agreement between myself and Semeji, my lord.
Now, if we look at the next document, it's also titled Quota Fees. Again, it's an email from Egil Anderson to you, dated 11th April 2018. I'll just read out the first part. It says, Dear Tamson, see below email that I have sent to the JV partners. I don't think no one is taking this seriously. You need to assist me with the matter because if the quota fees will not go down, then we'll be out of business. So what was he talking about? If in relation to the first quota fees and levies comparison and this quota fees document?
So my lord, the email, the previous one of document 56. So he's now informing me that if these levies, the one that I've just explained now, if they don't decrease, it will be a problem. So we will not be making money, then we will be out of business, my lord. So he's asking for my assistance to help him in this matter, to find a way how we're going to do it, to convince the authority to bring the quota levies down, my lord. And actually the quota fees, my lord.
Your Lordship, may the initial document 56 be marked as Exhibit B59.
Is it only
together with this attachment? 56.
Together with this one?
No.
Oh. Which one
just
is
the email together
okay.
with the attachment.
Okay, I see that.
Yes.
It will be Exhibit B59.
59, yes.
Yes.
So now you are talking about this quota fees document that you are being informed of by Egil Anderson. I see there's an attachment fee comparison.
Which one?
Quota fees, it's not numbered on top. The next one.
Yeah.
Yes.
Okay.
This is the one you are talking about.
Yeah, it's the one that I'm talking about now.
Okay. Your Lordship, may this document be marked as B60.
Would you say it's different from B59?
They are the same, actually, my lord. Plus the one that's the letter from PwC.
Can't we just have it go together with...
All together?
Yeah, because since it's not having a number on top.
Yes, Your Lordship, I think that is in order. Then we can just say that's B59.
Yes.
Yes, together with...
Okay, that's fine.
Maybe you can just explain the attached letter.
From PwC?
Yes.
So, my lord, this is a letter from Mati Amukwa, Executive Chairman, Confederation of Namibia Fishing Association, PO Box 2513, Walvish Bay. Dear Sir, recalculation of land values for selected fish species in terms of the definition of the Ministry of Fisheries and Marine Resources, collation of the cost of doing business data. Enclosed, please find the draft report of the key finding of the recalculation of the land value and cost of doing business exercise for horse mackerel sector per signed agreement letter dated on 30th January 2018. I trust that you will find this in order. Yours faithfully, Hans Hanschen, Director, Advisory Service, PwC. So, my Lord, the chairperson of the chairperson of the Confederation of Namibia Fishing Association also intervened in the increase of the quota. So they chose PwC to do a recalculation of the landed value. Landed values are those quota levy fees and all those things that has been described in that previous emails, my Lord. So they were also not supporting it, my Lord.
So, Your Lordship, as per agreement, it was indicated the whole of that bundle, including that letter, to be marked as B59.
Yes.
May I please the court. Now let's move on to 57. It says invitation letter and hotel booking. It's emails from Egil Anderson to you, dated 23 April 2018. It's very short, so I'll read it out. It said, good afternoon, amigo. Please find attached, as I was not sure, then I had this open. Best regards, Egil. And it shows that there is attachment, invitation letter, TAMSON HATUKULIPI, hotel booking, and so on. And then there is 2 letters from Noah Pelagic. So the first letter, I'll just try to summarize what it says. Invitation of Mr. TAMSON Tangeni HATUKULIPI to a business trip to Las Palmas, the Gran Canaria, Canary Islands, Spain. I'll just read out the first paragraph. To whom it may concern, we hereby inform that Mr. TAMSON Tangeni HATUKULIPI of Namibian nationality holding passport number P0519659 has been invited to a business trip to Las Palmas, the Gran Canaria, Canary Islands, Spain by the Spanish company Noah Pelagic LPA, and registered address at Professor Austin Milares at Las Palmas de Gran Canaria, Canary Islands, Spain. In this sense, Mr. TAMSON Tangeni HATUKULIPI is an external consultant of the Namibian company Kari Investments 180 Pty Limited, with registration number 122, registered address, at 122 Theo Ben Guriab Street, Walvish Bay, Namibia. Now, if you can just indicate what this email and this invitation letter from Noah Pelagic relates to.
Lord, Noah Pelagic is a married subsidiary. So they invited me for a business trip in Spain, Las Palmas. Because I have a consultancy agreement in place with them, Kari Investment and 180 and JTH Trading. And it's confirmed here that in this sense, TAMSON HATUKULIPI is an external consultant of the Namibian company Kari Investment 1802 Pty Limited.
Now, again, going to, okay, maybe before I get into that, if you look at the next document, is a reservation. I believe it's a accommodation reservation at a hotel Cristina Las Palmas. For yourself?
Last document?
Yes.
Okay.
Yes, the letter after the invitation, the last document, again from Noah Pelagic.
Okay.
Yeah, where it says arrival 15 May 2018, departure 15 June 2018. Now, you are saying that it's acknowledged that you, in this letter, that you were an external consultant.
That's correct, my lord.
Now, getting back to what Johannes Stephenson said, if you entered into dummy agreements and you were not really into any legitimate contractual agreement with Sameji, would it be acknowledged in such a letter, and would you have been invited to Las Palmas?
No, my lord.
And from the hotel booking, you can see that it was for a period of about a month, 15 May 2018 to 15 June 2018.
That's correct.
In Las Palmas.
That's correct.
What were you doing in Las Palmas for that month?
No, I did not stay for the whole month. We changed the arrangement later because we just went to go discuss the way forward. Because Ale now took over from Johannes Stephenson. So they invited me to Las Palmas to go discuss, because Ale was never most of the time in Namibia. He was just based there. So they invited me for that business trip now to discuss the way forward now.
Okay, and what did you conclude?
Excuse me?
What did you conclude when you discussed the way forward, if anything?
What we have concluded, my lord, it will come like in the documents on Amboma. And the last data will, that is in divide.
Okay, no, then we'll get to that.
Yeah,
but the reason I asked that because you said you went to discuss. So when there's a discussion, there's obviously some kind of conclusion.
No, we
discussion.
agree. We agree.
Some kind of agreement.
No, we agree, my lord.
Your Lordship.
Because we already had an agreement in place. There was already consultancy agreement.
You said someone took over from...
Yeah, it's Ale. When Johannes resigned,
Oh, okay.
yeah, Ale is the one who took over the operation of Sameji in Namibia. So he was the one who was in charge of the operation, my lord.
Briefly, what was the purpose of your trip?
They invited me for a business trip to to Spain.
Yes.
To discuss the way forward, how we're going to do our businesses and all those things, and to look at other opportunities in other African countries. So that was basically what we went to discuss, my lord.
All right. Yes.
May it please the court. Your Lordship, may that email together with the attached letters be marked as Exhibit B60.
Yes, it's marked B60.
May it please the court. Now moving on. There's an email from Adele Pay sent on 25 July 2018 to Egil Anderson, subject forward JTH Trading. It's also very short, so I'll read it out. It says, Dear Egil, I made this note to myself when I attend the last VAT audit in Windhoek. The tax officers at the ministry specifically requested that when we receive invoices for consulting fees, they want the service provider to add more detail on the nature of the consulting fees. In short, they should describe on the invoice what the consulting fees are for. Can you please ask them to add this to their invoice going forward? Kind regards, Adele. And there is an attached invoice. There's an attached email, JTH invoices to be amended.
I know it's not. It's not.
Oh, it's not?
No.
My apologies.
Okay.
Yeah. So 58 as is just that email.
Yeah.
Where did you get this email?
From the additional disclosure, my lord.
Okay. So the one made on 1st June 2023, as you've been saying.
Correct.
Okay. Now, what was this email? What does it speak to?
My lord, this email is from Adelpe, the chartered accountant of Sameji in Namibia. I think she attended last VAT audit, and she met some officials from the Ministry of Finance. Should be Ministry of Finance. She just said, yeah, Minister of Tax Officer at the ministry. And they made such certain suggestion that whenever JTH invoice They must not just say consultancy, they must at least add something. But this, my lord, was never communicated to me by Semeji, neither by the officers from the Ministry of Finance. So I only saw it now in the disclosure, my lord. That's why it was not implemented, my lord.
So you still continued to provide your invoices in the same manner?
That's correct, my lord.
And they paid?
They paid, yes, correct, my lord. And this was never communicated to me, my lord. That's why it was not implemented.
May I proceed?
May it please the court. Your Lordship, may this email be marked as Exhibit B61.
Yes, it's marked Exhibit B61.
May it please the court. Now moving on, we're on 59. It's an email, the heading is JTH invoices to be amended. Dated June 29, 2019, from Egil Anderson to yourself, CC Irene Rodriguez Pascal. It's also very short, so I'll read it out. It says, Dear Tamson, can you change the concept of the following invoices? From our side, the concept is not accurate. See below. I see here there's a table. Date is 14 March 2019. There's an invoice number, KJT19003. Amount is 3,622,500. Old reference consultancy fee. New reference sales deal commission. Then also the date of 24th April 2019. J invoice number KJT19004. 3,622,500. Old reference consultancy fee. New reference sales deal commission. Another date, 13 May 2019. Invoice just says 05. Amount 575,000. Old reference consultancy fees. New reference sales deal commission. Total is 7,820,000. Best regards, Egil. Then Irene Rodriguez Pascal. I believe she wrote an email to you on 1st July 2019. It says, Dear Tamson, please send amended invoices as soon as possible. Thanks and regards, Irene. And then to Egil Anderson, CC Irene Rodriguez, subject JTH, invoices to be amended.
Oh, it's from Tamson.
Yes, this is from me. Then it says, okay, my brother. That is on 29th June 2019. Now, what does this speak to? This document 59, the email.
My lord, as I said, that I continue invoicing them. Description consultancy fee. So on the 29th of June, as the only time they informed me that I must amend those invoices that I've submitted, the 3 invoices worth 7,820,000. So I must amend it and make the description sales deal commission. So this speaks of the clients that I've been introducing. So my commission that they've been paying me. And this is in line with the 2 pillars. Now they have now rectified. They started now correcting the invoices. So they've now made it clear that this is from the sales deal commission, my lord. The 7,820,000.
So are you saying, of course, from your invoices, it was indicated consultancy fees?
Correct.
They changed it to sales deal commission.
Now they have now specified that the money that we are paying you now is from the sales deal. Okay. Yeah. Usually they just used to invoice. I only used to invoice consultancy fee as per the agreement. Now they've now, it's now being specified now, Coach, this money, that this money from the this is from the sales commission of the fish that was being sold to the other to the other clients, my lord, that I've introduced.
Okay.
Yeah.
Your Lordship, may this email, together with, yes, the whole of this email, 2 pages, be marked as Exhibit B62.
Does your evidence in relation to this document change your earlier evidence to say you only got to learn about it through the subsequent disclosure? Because now it appears that you are saying they brought it to your attention through this letter that the description should be more than consultant's fee.
No, what I'm saying from the disclosure, what I've discovered, this was already communicated to them by the ministry. When the chartered accountant of Semeji attended the last VAT audit, certain suggestion was already made by the official from the Ministry of Finance. And this was only communicated between, so Adele only informed AIL. So I was not informed. If you look on top there, page document 58.
B61, my lord.
Yes.
Yeah, that one is now, that email is from Adele Pay, the chartered accountant of Semeji. So she attended a VAT in Vendu. So
Yes,
she met, yeah, you remember, okay.
I understood that one.
Yeah, so I only came to learn this email. It was never communicated to me. Yeah, I only found it in the additional disclosure.
You mean document 59?
58. No, 59 is for my email address, my lord. 59 is for my email address, my lord.
What is document 59 all about?
59, so AIL, they inform me now that the invoices that I've submitted on the 14th of March 2019, that says consultancy fees, I must change them. I must change consultancy fee to sales deal commission, my lord.
Yes.
Yeah.
Is that not in line with what was said at the meeting that the chartered accountant attended to?
That was in line, my lord.
Yes.
So I'm saying it was not implemented that time. That was now 2018.
Okay.
Because nobody communicated to me about it.
Is this not a communication to you?
I'm not copied into this thing, my lord. That's what I'm trying to say. It's from AIL, from Adele to AIL.
What, when it says to TAMSON?
No. Which one is that, my lord?
Your Lordship, I think
59.
there's a,
No,
there's a
50?
misunderstanding.
Document 59.
First of all, it's B61. B61 is the first email
Document
the applicant is talking about, 58.
Yes.
That this email is from Adele to Anaso.
Yes.
I'm sure the witness is in a position to explain himself.
Oh, okay.
For the record, not to be confused that my colleague is now the witness.
Okay. All right. That's fair.
Your Lordship, my learned colleague should learn to hold his horses. I can explain if I see some discrepancy, because I'm only saying, and I'm not testifying, from what has come out, because it seems there's some ambiguity. I'm talking about there's 58 and 59. So I'm saying 58.
Okay, let me just...
Let
Yes.
your
let me
client
explain.
just
May I please the court?
assist us.
My lord, document 58.
Yes.
If you look on top there, it's an email from Adele Pay.
Yes.
Adele Pay is a chartered accountant of Semeji.
Yes.
Sent 25th July 2018. Are you with me, my lord?
Yes, this, I don't have a problem with document 59. I understand it very well.
Okay.
Yes. It's just that how I understood your evidence was, after she attended, I don't know if it's a he or a she.
It's a she. It's a she.
Yes, after she attended this meeting at the tax office, it was brought to her attention that there should be proper description, if I may put it like that.
Correct.
But it was never communicated to you.
That's correct, my lord.
You only got to learn about it in the disclosure that was made.
No.
That's how I understood
No,
your
I
evidence.
only came to learn about it
Yes.
on this email that was sent to me by AIL.
Yes, that's what I was trying to clarify.
That one is not from the disclosure, my lord.
Okay.
Yeah.
You mean document 59 is not from the disclosure?
It's not for the disclosure. These are my own. It's from my email, my lord.
All right.
Yeah, okay.
Where is document 58B61 from?
From the additional disclosure.
You may proceed.
May I please the court? Now, the last document on this bundle from divider 2.
Should I maybe number this one? Document 59 as an exhibit?
Yes, it did so, Your Lordship. I believe that should be exhibit B62.
Yes, it's so marked. You proceed.
Proceed.
So, my lord, the emails that I have provided before the court, my lord, of divider 2, it clearly indicates or emphasizes the legitimacy of the agreements between myself and Semeji and my business dealing with Semeji, my lord. So those agreements, my lord, were legitimate, valid, and enforceable agreements for services provided. So, Mr. Kanyangela, during the bail application of former Minister of Fisheries, Mr. Bernard Esau, New Faith, and Nigel van Wyk, conceded that TAMSON HATUIKULIPI and James HATUIKULIPI, they were providing consultancy services to Semeji, and they were entitled to be paid for their services, my lord. That's what Mr. Kanyangela conceded 2023 on the bail application of former Minister of Fisheries. So, my lord, the then magistrate, Duarte Keslau, that denied me bail, made a ruling in his judgment that I was part of the plundering of resources for self-enrichment, and it's not in the interest of public to admit me to bail, my lord. So, my lord, let's first start with the definition of plundering. It's to enter a place by force and steal goods from it, my lord. My lord, my entry into the fishing industry is backed by binding and legal agreement. My role, as I've indicated, was to assist Semeji to partner with the JVs, market entry, and stakeholder relationship. Standard business practice, and I was paid for my work, my lord. My lord, those agreements were concluded in good faith and executed as such. Plundering implies by stealing and doing so by force, as per the definition, my lord. My lord, if there was any plundering of resources, I was never part of it, my lord.
Are you discussing, or are you saying that in relation to
I'm getting to that one, my lord.
Okay.
So, my lord, if there was any plundering of resources, I was never part of any plundering, my lord. I was doing business with Semeji, and those businesses were completely legal according to the Namibian law. Article 21 sub 1J of the Namibian Constitution, that guarantees all persons to carry on any trade or business. And Mr. Kanyangela conceded that I provided consultancy services to Semeji, and I was entitled to be paid. So, my lord, the then magistrate, Duarte Keslau, boldly and perhaps without full detail on how quota allocation processes work, and he made a ruling that I was part of the plundering of resources for self-enrichment, and that fish at our coast that was supposedly to be harvested for the good of all Namibians, and greed is not in the interest of public to admit me to bail. So, my lord, now we come now to document 60. This is an
maybe how do you understand the respondent's case on the issue of rendering of consultants' work? Is it that they say you never at all rendered any consultants' work, or they are questionable transactions.
That's correct, my lord.
Which one?
They say I did not render any services, my lord.
Okay.
Yeah.
Proceed.
So, my lord, this is an internal memorandum from the Ministry of Fisheries and Marine Resources, sent to Honorable Bernard Esau, Minister, CC, Honorable Chief Samuel Ankama, Deputy Minister.
All right, just hold on there.
My lord, this document brings us to the application that we brought on Tuesday. This document comes from the disclosure that was made way before even the second bail application was held. This document was with the applicant even before his second bail application. He chose not to produce it. The judgment that I have already quoted in my application of Tuesday clearly shows that an applicant cannot be allowed to provide evidence piecemeal so as to claim it as new facts. And that is why we are objecting to the use of this document, which was already in the hands of the applicant for his second bail application. That is impermissible according to those authorities.
Well noted.
Mr. Court, please.
Please, the court. Your Lordship, my learned colleague will have his bite at the cherry when he cross-examines. The applicant just started referring to this document. He doesn't even know why he's referring to it, and he already jumps up and objects. He should first wait and hear what is the essence. The applicant already testified to what the magistrate in the Quota indicated, the then magistrate, Mr. Duart Keslow, and what was said by Mr. Kanyangela in the subsequent bail application. And then he referred to this document. He should wait and hear on what basis is he referring to this document.
And then it will be handed in as an exhibit?
Your Lordship, it can be handed up. It depends on in what reference the applicant is using this document. But my point is, again, it's what we said on Tuesday. These are malicious objections by the respondents. In the first place, they didn't even want this bail application to take place because according to them,
I don't expect
it's not
you
new facts.
to go to that extent.
Yes.
He has just registered his objection, and in my view, he's right to say if it was available to the applicant and he chose not to use it, he shouldn't attempt to use it. But I'm prepared to hear the context in which he wants to refer to this document.
Indeed, so Your
But
Lordship.
I can indicate to say that the court can still disregard it if it will not amount to new fact.
Indeed, so Your Lordship, but
Yes.
again, the respondents made reference to their objection on Tuesday. Why are they still, backing at, a thing that was already gone? Because the court made a ruling. Now we cannot go back and start saying it's the same reason why they made the objections on Tuesday. And that's why I made reference to that.
The essence, I still understand what he was arriving at, but you may proceed.
May I please the court?
My lord, this is an internal memorandum from the Ministry of Fisheries and Marine Resources, sent to Honorable Bernard Esau, Minister, CC to Honorable Chief Samuel Ankama, Deputy Minister, from Ms. Waitala Ivelwa, Permanent Secretary, date on the 1st of July, 2014. Subject, additional horse mackerel quota allocation for the 2014 fishing season. Introduction. The proposed total allowable catch TAC for the 2014 fishing season has been set at 350,000 metric ton. This is the same as the 2013 fishing season. Initial allocation for 2014. During 2014, initial allocation is 220,000 metric ton was allocated to the mid-water fisheries on pro rata. An allocation of 16,000 metric ton was made to the non-right holders, which includes Namibia Fish Consumption Promotion Trust and Gendev Group for the horse mackerel land-based processing. 2. Proposed allocation. 2.1. Allocation of 92,104 metric ton of horse mackerel is to be allocated as follows. 50,104 metric ton to be allocated to all right holders. 42,000 metric ton to be allocated to non-right holders. Allocation of 42,000 metric ton to non-right holders to be allocated as follows. 10,000 metric ton to National Fishing Corporation, FISHCO. Namibia-Mozambique Agreement, 8,000 metric ton to OSIS. 1,500 metric ton to Marazu. 1,500 metric ton to Birama. 8,000 to Small Pelagic Association. 7,000 metric ton to Namibia-Angola bilateral agreement.
So in brief, is it not about allocation of quotas?
So what I'm trying to say, my lord, this document clearly indicates that fish at our coast, that is a national resources, was harvested in the interest of Namibians for the good of all Namibian right holders in the fishing industry, my lord.
How do you bring that issue to the document?
Because this document clearly shows that all the people that are mentioned here are all right holders. And quota can only be allocated to right holders. Now I'm being told that the judgment is made that I was part of plundering of resources. So this...
Yes, what is the connection between the two?
The
judgment that you are not happy with and this document.
Because
this is quota allocation.
Correct.
Yes, which you are saying it was rightly done.
Correct.
Yes.
Which I'm trying to show the court that I'm not part of the allocation of quota processes, my lord. Because it's made that I was part of plundering.
Are you saying that the judgment saying that you plundered resources
Correct.
was based on this document?
The resources that must be plundered, because the fish must come from the Ministry of Fisheries, and it can only be quotas.
Okay, probably it's an issue to argue. We can look at the context in which that remark was made.
Okay.
Yes, what informed that decision. It can be argued.
Okay, my lord.
Yes.
Okay.
Because in any case, it's obvious that there are quota allocations.
Okay, my lord.
Yes, there will be entities that will be allocated quotas.
Okay.
Yes, there is no doubt about that.
Okay.
You don't even need to prove that.
Okay, my lord.
Yes.
Okay.
Yeah.
My lord, it's clear, my lord.
May it please the court, your lordship will not ask for this document
Okay,
to be
no,
tendered into evidence.
That's
I think the explanation is sufficient.
yes.
And just to avoid any objections. But nevertheless, we'll move on with in the interest of time.
Okay.
Now let's move to ground 7 of your new facts, which indicates additional disclosure consisting of mostly emails from Iceland was only provided to you on, it says here, 3rd June 2023, and as such, applicant will have to go through it thoroughly to consult and also consult with lawyers. That is your ground. What do you have to say about it?
My lord, I went through the additional disclosure, through some of the files, my lord, and I'm not yet done going through everything. And these are the disclosures, additional disclosure that was provided to me on the 1st of June, 2023, my lord.
I thought part of your reason why you are before court is because of the disclosure that was made.
That's correct, my lord.
And you are saying you are not yet done going through that disclosure, but you are already before court.
No, there is only like 3 files. It's only talking about statements, bank statement, my lord.
Okay.
Yeah.
Now, with regard to that additional disclosure, of course, you've gone through some of them. Have you consulted with your lawyers with regard to the additional disclosure in preparation for the trial?
Yes, I did, my lord.
With regard to all the files? For the additional disclosure?
Except the one for the bank statement, my
For the
lord.
bank statements?
Yes.
So that is still pending?
Correct, my lord.
Now moving on to point 8. It says, as per the additional disclosure, applicant was never part of the Namgoma case, and applicant was also never part of the bilateral agreement between Namibia and Angola. What do you have to say about that?
My lord, I was never part of this Namgoma.
Yes.
And this has also been confirmed by the director of Namgoma, my lord, during his bail application on Newfake, Ricardo Gustavo. The question was raised by Mr. Lutumbezi at page 181 of his bail record that you said you know TAMSON. Was he involved in this Namgoma project? Ricardo replied that no, TAMSON was not involved as far as I know. James Hatwikulipi was involved with Namgoma Peshka Limited.
Was that in Mr. Ricardo's bail application?
That's correct, my lord. Page 181. He's the director of Namgoma, my lord.
Can proceed?
My lord, this is document.
Or are you referring the court now to a document?
Oh, okay, sorry, my lord. Sorry. And a question was further raised by Mr. Lutumbezi, page 223 of Mr. Gustavo, saying that in your letter, you indicated that Namgoma Peshka is owned by Namibians and Angolans. So the question that I have, who are the Namibians? So Mr. Gustavo replied that there is no Namibian in Namgoma Peshka, SA. Namgoma Peshka is 100% owned by Angolians. Then at page 197, Mr. Lutumbezi continued that were you acting on behalf of Namgoma Peshka Limited? Mr. Gustavo said, I was acting on instruction of Namgoma Peshka Limited, who are 100% owner of Namgoma Peshka Namibia.
Repeat your last statement. He was acting
on instruction of Namgoma Peshka Limited, who are 100% owner of Namgoma Peshka Namibia. So,
yes.
So page 224, Mr. Lutumbezi continue asking, so in your letter, you indicated Namibians, Namgoma Peshka. How many Namibians? He said there were no Namibians. No, he said, no, sorry, my lord. He asked, in your letter, you indicated Namibians. How many Namibians? So Mr. Gustavo said it was himself and other entity that was thinking of bringing on board of his former business partners, my lord.
Mm-hmm. Yes.
Yeah. Okay. Sorry?
There's something.
Now, I was just finding out from my learned colleague, Your Lordship, if he noted down the page numbers according to what the applicant was referring to.
The essence of what he's saying is to say that according to the evidence of Mr. Gustavo, you were not involved on the Namgoma.
Peshka.
Yes.
Namgoma project.
That's the essence of your evidence.
Ricardo Gustavo is the director of Namgoma.
Yes. I understand.
Okay.
Please, the court. Now, before I stopped, you wanted to refer the Honorable Court to some documents.
Oh no, we can start, my lord. Document number 61.
Okay, under which divider is it?
Our divider 3.
Okay.
So, yeah, 3.
Please proceed.
So, my lord, document 2 of 3 of this document says communications. The email on the bottom from Zacchaeus Edward Shangala, sent Friday, August 9. So we sent on the 9th of August 2013 to Francisco Antonio Santos, copied Ricardo Etunga nam.com. It's now written in Portuguese, my lord. The subject. So I can just see that Ricardo Gustavo will email you soon. Antonio. Antonio is now, those are the owners of Nampeska, as per the disclosure, my lord. And then up, it's again an email from Ricardo Gustavo, sent on the 24th of August, sent to Francisco Antonio Santos and Zacchaeus Edward and James Hatwikulipi. Subject, visitor Luanda. So the same communication was forwarded to Johannes Tessenden from Saki Shangala on the 24th of August 2013. So Johannes sent an email on the 24th of August to Saki Shangala and James Hatwikulipi, subject visitor Luanda. Dear Saki, 16 and 18 September is good for me. Thanks, regards Johannes. Then Johannes sent this communication to myself, my lord.
Now, apart from receiving this communication from Johannes, did you have anything to do with the contents of it? In other words, the subject,
Not at all.
the visit to Luanda?
Not at all, my lord.
Your Lordship, may this document 61 be tendered into evidence and be marked as Exhibit B63.
I just want to understand the reason for submitting this document.
Yes, my lord. Maybe I should let the court do, because I also had an objection to it.
Let me hear you.
Yes, because there's absolutely nothing on the top there that links whatever email communications below that they were indeed forwarded to, that they were the ones that were being forwarded to Mr. Thompson. Because there's the blog of Mr. Thompson, I don't know if it's blacked out, but there's absolutely nothing. He just read Johannes Stephenson to TAMSON HATUIKULIPI, and that is where it ends. From there, there are email communication downwards. We don't know now what is the purpose of the block on top. How is it linked to the email communications that are below that? There is absolutely no link between the two.
Okay, so the middle column that starts from Johannes Stephenson is different from the top part. It's not going together with the top part of Johannes Stephenson and to...
Yes. Because the one in the middle, my lord, you realize that it only says from Johannes Stephenson to Saki Shangala, CC James Hatwikulipi.
Okay.
And those are the people that received that. It does not show that it was then also CC'd to the applicant before this court. Neither is there any indication that it was forwarded on at least face value of the document that is now being brought.
Okay.
My lord, if you look on top there, the top of the first email, it says forward visitor Luanda. It's forwarded to who now? If Mr. Ipike can answer me that.
Your Lordship, maybe just to intervene, you know, my learned colleague, you know, for the respondents has a habit of, in fact, according to him, maybe almost everything doesn't make any sense. You know, it's one thing to ask for clarity, and he can do that maybe if he feels that it doesn't speak to what is in the body of the email. It's another thing to say that there is no connection. That is the conclusion he's making, without getting it from the horse's mouth. And the horse here is the applicant who is on the stand. These emails are from the applicant. And as the applicant has testified, it is as crystal clear as daylight.
Okay,
The heading of the email says forward. It's forwarded.
Let's allow him, because as I was also inquiring, it will tie in together to assist what it's all about, just to clarify.
May it please the court?
Yes.
My Lord, so this email is from Johannes. He sent it on the 24th of August 2013 to Saki Shangara and James Hatwikulipi. Subject: Revisitor, Luanda. Dear Saki, 16 and 18 September is good for me. Thanks, regard, Johannes. So Johannes then forward this.
So all this, you mean all this document or email was forwarded?
No.
Yes.
If you look from page 2 of 3, I think communication started there.
Okay.
And then from there, on the page 1 of 3, there's an email from Saki on the 24th of August to Johannes Stephenson. Forward, visitor, Luanda. And then, on top of that, Johannes, same day, 24th of August 2013, sent to Saki and James, Revisitor, Luanda. Dear Saki, 16 and 18 September is good for me. Thanks, regard, Johannes. I don't know now how did he come to answer that. What was their communication? If they called each other. So they were prepared. You can see that it's a visitor. I think visitor means visit, a Luanda.
Yes, Mr. Siwamanji?
May it please the court? So you are saying that this communication was forwarded to you as per what is indicated on top?
By Johannes Stephenson,
Yes.
yes, my Lord.
I hope that is clear. May it please the court? Your Lordship, may this document be tendered into evidence. I believe the last exhibit is B62, maybe marked as B63.
It's marked exhibit B63.
May it please the court? Your Lordship, I see it's almost 3:45. We're in the court's hands.
Let's take it until 1600 hours.
May it please the court? Now let's move on.
So, my Lord, document 62.
Yes.
It shows that from Sigwa Olasen, sigi@asiafishing.com, sent on Tuesday, 26 November 2013, sent to Johannes Stephenson, Tia Twikulipi, Jimo Edmek, Joao de Barros at hotmail.com, Saki, and copied Margaret Olderstoy. Sorry, my Lord, the surnames. Subject summary in Angola-Namibia. Attached summary, Angola-Namibia project. Here is the meeting summary regarding our project in Angola and Namibia. Best regards, Sigi. So, my Lord, the reason the following doc page after this was submitted by the state, my Lord, in the previous bail application in their bundle. It was document 26 in their bundle. But the front page was not there, my Lord. So when I went through the disclosure, I found these documents, my Lord. Because it was made as if these notes was written by my co-accused. So they did not provide the first page, my Lord. That
Which co-accused?
My the one that I mentioned here, my Lord, in the summary of Angola.
Are their names?
Yeah, the names are there, Saki and James. So the way it was presented, it was as if it came from one of my co-accused.
Your name also appears.
Yes, that's what I said, my Lord.
But as per this document, as per the cover that you've indicated, the second document was produced, but we don't know whether it's by omission or deliberately why the first page was not disclosed.
That's why now I was now wondering, why was the front page not disclosed, my lord? Why was it not provided?
Does it make much difference?
No. The reason why I'm saying that, my lord, if you look in Johannes Stephenson's affidavit,
Yes.
he said the same person that sent this email had nothing to do with corruption. Which means he's the author of this document. So it was what they said
Repeat your statement.
in Johannes Stephenson's affidavit.
Yes.
He indicated that Sigwa Olasen was never part of any corruption. Sigwa used to work for Semeji, my lord. And the same Sigwa is the one who's writing these notes. Samari Angola-Namibian project.
Is it what the document says, that he's the one who is writing it?
On top, yeah, the first page that was not provided by the state, my lord. And this document, it's in their bundle, document 26, my lord.
So just to get clarity and just to understand what you are saying, are you saying that the second page of this document, which is the summary Angola-Namibia project, was disclosed? That is the document 26 in the initial bail application?
For the state bundle.
Yes, the state
Correct.
bundle. But either by omission or deliberately, the first page, which you've provided now, that is on 62, you know, that the first page actually shows the author of this document.
That's
from
correct.
where it came from.
That's
that
correct.
was not disclosed.
It was not disclosed, my lord.
And it was purported as if it came from, as it indicates on the document, Saki, Thompson, and James, from the document, that you are the authors of this document.
That's correct, my lord.
Yes.
May it please the court. Your Lordship, may this page, we really have no interest, but they speak of the same thing, but we want the first page.
For the record,
Your Lordship, it is not court decorum. I'm standing, you know, I'm addressing the court.
Okay,
My
he
learned
wasn't
colleague has
yet
already
done.
gone up.
Maybe allow him first. Mr. Siomunji?
because I thought he was moving on to the next point, and I'm addressing the previous point.
I understood him as if he wanted to have it marked as an exhibit, but he did not yet conclude his statement.
No, before the marking, my lord, it's just to say that there are now accusations being made against the state that it was portrayed that it came from the co-accused persons. My lord, the record is there. When this document number 26 was presented, if the witness can also show where in the record those impressions were created, because we only dealt with the document.
You want to register your stance on this aspect?
Yes,
because you could even probe it in cross-examination.
Yes.
To simply say, show me in the record where
Yes.
yes.
Because just for the record, there was no such impression created that it came from
it's
the co-accused person.
It's fine.
Your Lordship, as the court rightly pointed out, that is an issue to canvass in cross-examination. And if my learned colleague is disputing that that was not the case, then in cross-examination, you'll have the record, you know, of the proceedings. He'll be able to point out and address that issue.
Yes, it's fine, but here it's almost like a misstatement. So he just wants to have the record reflect the truth. But he can still pursue it in cross-examination, because then he will be able to show how the impression was created.
So it means the objection was unnecessary, Your Lordship, but nevertheless, we'll move on. May
So
this
yes, can I mark
document
it as
be
an exhibit?
marked as exhibit B64.
It's marked as exhibit B64.
May it please the court. Your Lordship, before we move on to a new point, which might take a bit of time, I see it's 10 minutes to 4.
Okay.
I believe this is opportune time for us to adjourn for the day, and we'll continue in the morning.
Okay. Is there anything you'd like to say before I adjourn proceedings?
None, my lord.
Okay.
Yes.
We'll continue tomorrow at 9 o'clock.
Is the court, please?
Court
Please,
adjourned.
the court.